Hello friends, today we will learn about the section 52 of the Transfer of Property Act 1882, which explains the doctrine of Lis Pendens. In simple word, if there is a court case pending on a property, the owner of the property should not sell, transfer or deal with such as that the property affects the right of the people involved in that particular case. This act protects the court decisions as well as it stops anyone from avoiding the final judgment by transferring the disputed property while the case is still ongoing. Now the term lis pendens is a Latin term where the lis means the legal dispute or litigation and pendens means pending. So together lis pendens means a dispute that is still pending before the court. The basic rule is very simple. If a court case about a property is ongoing, the property should not be sold, transferred or dealt with in a way that affects the right of the people who are involved in that case. These rules make sure that no one can defeat or avoid the court's final decision by transferring the disputed property while the case is still pending. The main object of the doctrine of lis pendens is that to protect the property that is under dispute while the court case is still ongoing. It stops the parties from selling, transferring or dealing with the disputed property in a way that may affect the right of the other parties of the court's final decisions. The doctrine makes sure that the court final judgment remain effective and can be properly enforced. The rule based on the necessary and public policy, it helps to maintain the fairness and prevent anyone from avoiding the court final judgment or decision by transferring the property during the case. In a simple word, section 52 of the Transfer of Property Act 1882 ensures that everyone involved in the dispute must follow the court's final judgment. Now there are certain conditions for the application under section 52, which is doctrine of lis pendens. Okay, for the doctrine of lis pendens to apply, there are certain conditions which must be fulfilled. The first condition is that there must be a pending suit or legal proceeding before a competent court. The case is considered pending from the date of plaint is filed. It normally continues until the court passes the final judgment or decree. In some situation, the pendency may continue even after the decree, such as when an appeal is filed or execution proceedings are still ongoing. However, the case is filed in a court that does not have the legal authority or jurisdiction to hear that case, then the section 52 will not be applied. Okay, so the doctrine of lis pendens applies only when the property dispute is legally pending before a competent authority or competent court. Now the second condition for the application of doctrine of lis pendens is that the suit must be filed before the court that has the proper jurisdiction to hear the case, as I have just explained. The competent court is one that has the legal authority to decide the dispute based on the factors such as territory, subject matter and the value of the property involved. So the suit filed in the court that lacks the jurisdiction, the doctrine of lis pendens will not apply. Therefore, proper jurisdiction is very essential for the operation of section 52 for the Transfer of Property Act 1882. Now let's understand the third condition, which is called subject matter or immovable property. The case must be directly related to an immovable property. In other words, the court must be deciding who has the legal right over that particular property. This could not be a dispute about ownership, possession, partition or specific performance of that property agreement. If a case is not mainly about the property, when the doctrine of Lis Pendens, then the doctrine of Lis Pendens will not apply. For example, if we say a landlord files a case only to recover the unpaid rent from the tenant, the dispute is about the money recovery, so not about the who owns the property. So if the landlord sell the property during that particular case where he has claimed the money recovery, the transfer is generally not affected by the section 52. Now the scope of the transfer under this section 52. First is sale. So if a person sell an immovable property while the case relating to the particular property is pending, the sale is covered by the doctrine of Lis Pendens. Second is mortgage. If the owner creates a mortgage or any charge over that particular property during the pendency of suit, it is also covered because it affects the right of the property. Then third, gift or lease. If the property is gifted or leased during the pendency of litigation, these transfer are also covered if there is an effect of the right of the parties. Okay. So it is very important to remember here is the section 52 applies only to transfer of immovable property. It does not apply a movable property like vehicle, furniture or machineries. It does not apply. Okay, it's only apply for the immovable property like your flat or house. Now let's discuss the fourth condition. Fourth condition is no fraud or malafide intention. The lawsuit must be genuine and filed with a good faith. If a case is fake or dishonest or filed only to cheat someone, then the doctrine of Lis Pendens will not apply. For example, suppose the owner with other defendant work together and then file a false case against owner to defeat the right of that innocent buyer. In such situation, the buyer may still be able to protect his right because the suit was filed with a malafide intention. Okay, so this is a very important point in section 52 to protect genuine litigation, not the fraudulent lawsuit. Now let's discuss the fifth and sixth conditions together, which is transfer by party and effect to the other party. So first, the transfer must be made by one of the parties to the suit. If the person who is not the party transfer the property, section 52 generally does not apply. Second is that the transfer must be affect the right of the other parties. In that case, if the transfer does not interface with the right of the opposite party, then the doctrine of Lis Pendens will not apply. Also, if there are multiple plaintiffs, only those whose rights are actually affected by the transfer can claim the protection under this section 52. Transfer must be made by a party to the suit and then it must be affect the right of the other parties. So that is the fifth and sixth conditions. So these were all conditions of when someone wants to file a case under section 52 of Transfer of Property Act. Now before we conclude, let's quickly revise the important points about section 52 of the Transfer of Property Act 1882. The main purpose of this pendens is to protect the court's final decisions. It prevents any transfer of the disputed property that could further complicate the court's judgment. Okay, so section 52 applies. There are also certain conditions to be satisfied. Those are 6 conditions which we have discussed. There must be a pending suit before the competent authority. The dispute must be involved by immovable property. The suit must be genuine. The transfer must be made by the party to the suit and must be affected the right of the other parties. Also remember, the section 52 applies only to the immovable property. It does not apply movable property or the case filed before a court which does not have the jurisdiction. And third case, the fraudulent or collusive suit. Okay, so these are the certain case where section 52 does not apply. In short, section 52 ensures the fairness by protecting the right of all the parties and preserving the authority of the court until the case is finally decided. So that was all about the section 52 of Transfer of Property Act 1882, Doctrine of Lis Pendens. I hope you understand this section. Thank you for watching.